Good afternoon, everybody. Thank you very much for joining this, the third lecture in our series and the fourth session following the seminar on Friday. So the program for today is that I'm going to summarize a few of the key points that emerged from the second lecture. And at the end of that, we can discuss any questions or any comments that you would like to post on chat. So if you can do that over the next few minutes, any questions or any comments that you had arising from the second lecture or arising from our first seminar on Friday. Following that, we will begin to talk about multilateral financial institutions as intergovernmental organizations. And if we have time, we will then talk about membership and governance, although we will probably continue to talk about that at the lecture on Thursday. So that is the program for today. So to begin with then, in the second lecture, we looked at the evolution of international financial institutions, beginning with the creation of the Bretton Woods institutions in 1944, in particular the International Bank for Reconstruction and Development, the IBRD. We observed the creation of subsequent international financial institutions, and we looked at the factors that had led to their establishment. We learned about the emergence of other global international financial institutions, notably the IFC, IDA, and IFAD, all of which are UN specialized agencies. We saw too the emergence of regional IFIs, the Inter-American Development Bank, the African Development Bank, and the Asian Development Bank. We noted that the most recent large international financial institution, the Asian Infrastructure Investment Bank, the AIIB, has characteristics of both global and regional IFIs. Global because of the sheer number of members and because of the ability of the AIIB to invest in any member country, but also regional because its purpose is to promote a particular region, namely an expansively defined Asia. During this survey of the IFI evolutionary landscape, we observed a number of features that are common to most such institutions, and some features that are special to only one or some. We also noted a number of evolutionary trends, with later organizations building on what had preceded them. So drawing on these considerations, we may highlight the following factors. First, all IFIs are concerned with development, even if their stated purpose is sometimes expressed differently. So we see the World Bank and some of the regional IFIs as viewing their mandate in terms of reducing poverty or eliminating extreme poverty, or more recently, promoting more equitably distributed wealth. This is so, even though the charter of the IBRD makes no express reference to the concepts of poverty or the equitable distribution of wealth. However, despite the differences in the express language of their charters, all IFIs assert that their operations are aligned with and help achieve the United Nations Sustainable Development Goals, which are indeed very much focused on poverty generally and development more broadly. The same can be said about climate change. Secondly, the role of the private sector in development is far better understood today than it was in 1944. The IBRD has always been limited in its operations by the statutory requirement that it obtain a guarantee from its members for any lending that benefits them. However, the regional development banks are able to finance projects in both the public and private spheres. In the case of the AIIB, it has a target reflected in its corporate strategy of achieving an equal mix of private and public projects by the end of this decade. The vast bulk of EBRD financing is already in the private sector. And of course, all of the IFC's financing is and has always been in that sector. So it's much better recognized today than it was 75 years ago that the private sector plays a critical role in development and that the international financial institutions need to be able to support the financing of the private sector. Thirdly, IFIs are prohibited by their charters from taking into account anything but economic considerations when making investment decisions. The exception is EBRD, which has express political conditionality. Nonetheless, IFIs generally cannot be blind to political factors that have a bearing on economic considerations. For example, how pervasive corruption is in the countries borrowing from the IFIs or hosting the projects they finance. Fourthly, IFIs are owned and controlled by developed countries, which are not themselves borrowers, an arrangement underpinned by voting strength being mainly a function of economic strength. This has sometimes led to criticism that the rich countries are imposing unreasonable conditionalities on the poor borrowing countries. The rich countries counter that conditionalities are appropriate and designed to ensure project objectives are met and that the capital of the institution is protected. The exception to this model is the AIIB, which is majority owned and controlled by developing countries, the same countries which are expected to borrow from the institution, and indeed in many cases have so borrowed. Let me now proceed to the next part of today's program. You have a set of slides that deal with multilateral financial institutions as intergovernmental organizations. Sometimes the terms we use can be confusing. This is particularly so when some of them are used interchangeably. If you find that these terms that we are using are confusing, then you are not alone. Take, for example, the term international organization. What do we mean by that term? Here, helpfully, there is a treaty that provides a short definition, and there is a recommendation of a body that advises the UN that provides a fuller definition. Looking first at the treaty. The Vienna Convention on the Law of Treaties of 1969 refers to international organizations. A definition is provided, and the term international organizations is defined as meaning an intergovernmental organization. There are 2 points to note here. The first is that intergovernmental organization is not further defined, or not defined at all, in the Vienna Convention on the Law of Treaties. And the second point to observe is that not all countries are party to the Vienna Convention. Most industrialized countries are party, including Japan, but not, for example, the United States and France. In the case of the United States, it has signed the Vienna Convention, but it has not yet ratified it. In the case of France, it objected to those provisions of the convention that deal with jus cogens, and therefore it did not sign the Convention. So to digress for a moment to explain that point further, under the Vienna Convention, a treaty is invalid if it violates a peremptory norm of international law. That's the concept of jus cogens. However, the definition in the Convention of International Organizations as international organizations merely reflects customary international law, which is binding on all states, including the US and France, and indeed international organizations. Let me repeat that point in a slightly different way, because it's a little bit complex, but it's important. So the Vienna Convention is often referred to when an international organization or another body that is subject to public international law, like a state, seeks to interpret a treaty. And sometimes the objection is raised that not all countries are members of that treaty, and therefore the value of that treaty is limited, or maybe even applying that treaty is considered to be inappropriate. And here it's important to look at what treaties often do. Sometimes, as in the case of the Vienna Convention, they codify rules of customary international law. And then, again, with the Vienna Convention, they go on to provide for new elements that are not recognized by customary international law. And these are referred to as being part of the progressive development of law. So in the case of France, they did not like some aspects of the new development of law, and therefore they did not sign the treaty. And therefore the treaty itself does not bind, say, France or the United States, which has not ratified the treaty. However, those provisions in the treaty that simply codify public international law, those do apply to all subjects of public international law, such as France and the United States and international organizations. And so those provisions that are codified in the Vienna Convention, they do apply to all, but not because they're in the Vienna Convention, but simply because they already exist in customary international law. And so the question one always has to ask is, if something appears in the Vienna Convention, is to ask, is this part of customary international law, in which case it's binding on everyone, irrespective of whether they signed it, or is it part of the progressive development of law, in which case it's only binding on those who have signed and ratified the treaty. So in terms of definitions and understandings of what is meant by an international organization as an intergovernmental organization, I think that that is merely part of customary international law. So customary international law recognizes as international organizations, intergovernmental organizations. So that's binding on everyone. Now, the International Law Commission, which operates within the UN system and has prepared draft articles on the responsibility of international organizations, also has a role to play here. So these draft articles have not yet been adopted, hence the name draft articles. And in some respects, this is because they are quite controversial. However, they do provide a definition of international organizations, and I believe that the definition itself is not controversial. And the key elements of the definition are that an international organization is one that does three things. First, it is established by treaty or other instrument governed by international law. And secondly, it possesses its own international legal personality. And thirdly, it may include as members not only states, but other entities. We may consider further the definition of international organizations provided by the International Law Commission when thinking about international financial institutions. So, taking the above 3 points in turn. So the first, according to the draft articles prepared by the International Law Commission, international organizations are established by treaty or other instruments governed by international law. So in the case of IFIs, the major IFIs, they are all established by treaty. These treaties are often called an agreement, as in the agreement to establish the EBRD, or they are referred to as articles, as in the Articles of Agreement of the AIIB. So the difference between articles and an agreement is not legally significant. Now, the treaties that establish the IFIs are all governed by international law. So it is international law that makes possible the creation of international financial institutions. They have all been created by treaties. So international financial institutions are created by treaty under international law. So in short, they are governed by international law. Their constituent agreement, the Charter, is the most important document of the institution. And it governs not only the existence of the organization, but also its organization and its activities. Now, let me say a few words regarding the role of treaties. We may note here that in addition to international financial institutions being governed by the treaty that created them, they are also governed by other sources of international law. For the non-lawyers among you, for now, just note that the sources of international law are set out in the Statute of the International Court of Justice, which is contained within the Charter of the United Nations. And international financial institutions, like all subjects of international law, are bound by treaty obligations that they have entered into, as well as by customary international law and general principles of law. Maybe I can help clarify this by providing an example. So, under the Vienna Convention on treaties, one aspect of it, which I believe is reflective of customary international law, which means that it is binding on everyone, is that certain persons are deemed to have authority to sign treaties without any additional proof being adduced that they have the authority to do that. And these, to oversimplify, are the head of state, the head of government, and the Minister of Foreign Affairs. So if any of those persons signs a treaty, there is no need to seek confirmation that those persons have been authorized under their domestic law to sign the treaties. This is assumed. In the case of international financial institutions, over the years, a new category has emerged, and that is when a guarantee agreement or a sovereign loan agreement is signed by the Minister of Finance, then equally there is no need to seek confirmation from the state which is party to those documents that the Minister of Finance had authority to sign. In the case of international financial institutions, the practice is that no such confirmation is sought because it is accepted that ministers of finance have authority to sign loan agreements and guarantee agreements with international financial institutions. So you can argue that this has become or is becoming part of customary international law, and it's certainly an established practice of the international financial institutions. So in the case of all international financial institutions, then they apply the Vienna Convention on treaties when interpreting their own charters, and in relation to that aspect that deals with the authority to sign loan agreements and sovereign guarantee agreements, the international financial institutions have developed a practice whereby the ministers of finance need not adduce evidence that they have authority to sign. It is accepted that as a matter of customary international law, possibly, and certainly as a matter of established practice, there is no need for them to do that. Finally, with regard to treaties, we may also note that the United Nations Charter calls for treaties to be registered with the UN by the contracting member. At the time when the UN Charter was prepared, there was some discussion about whether registration of a treaty would be a precondition to its validity, or at least to its enforcement. However, it was decided ultimately that that would not be required, and so there is an obligation for treaties to be registered, but whether they are registered or not does not affect their validity. And the reason for registering them is because when the UN Charter was established, there was a desire to move away from a system which was quite broadly applied previously, whereby many important treaties were not known. So there were many secret treaties, and many of these had a pernicious effect in relation to war and to certain belligerent activities. So the idea was that there should be transparency. All of these things should now be registered, but the UN did not go so far as to requiring that there be registration as a precondition to enforcement. Now, an international organization itself cannot register a treaty, although an exception is made for specialized agencies of the United Nations. And as we saw, those specialized agencies of the United Nations include a number of international financial institutions, specifically the IBRD, IDA, IFC, and IFAD. So the loan agreements that international financial institutions enter into with states and the guarantee agreements that international financial institutions enter into with states constitute treaties. The state party is able to register that treaty with the United Nations. The specialized agencies of the UN are also able to do that. However, the IFIs that are not specialized agencies cannot register treaties. So this situation has led to a number of discussions over the years about whether international financial institutions generally ought to ensure, one way or another, that their international agreements are registered with the UN. So when the IBRD was established, this was not so difficult because they were the only international financial institution. The number of sovereign loans and sovereign guarantee agreements were quite limited. So it was an achievable objective. But over the years, this became more difficult. And it was not only because of the proliferation of the number of international financial institutions, or even the proliferation of the number of agreements because of the sheer increase in the number of projects being financed. It was also because there are many, many amendments, often relatively technical or substantively relatively trivial, which nonetheless constitute amendments, but it would become very burdensome for these things to all be registered. So the IBRD has persevered in registering all of their agreements, and this is true, I know, from my own experience with IFAD. I believe it's the case with IDA. Also, as you know, with the IFC does not deal with sovereigns, it's only with the private sector, so the issue does not arise there. At one point, the United Nations changed some of its technical rules to do with the registration of treaties, so it's no longer necessary for everything connected with the international agreements to be registered. So if you want to see what the international agreements are that the IBRD has entered into, you can search the UN website and you'll be able to identify the names of the parties and the names of the projects. You cannot always see the agreements themselves, and you cannot see them online, but at least you will know of their existence, and it's then possible through one way or another to obtain copies of those agreements. But that's the specialized agencies. So with the other international financial institutions, the regional ones, which came later, they did not have the power to register a treaty. And if they were making a sovereign loan to a country, often the sovereign borrower either was not particularly interested in registering the treaty, or didn't have much experience on how to do that, or in fact didn't even want to do that. So what has happened is that at the international financial institutions that are not specialized agencies of the UN, they have not registered their treaties. So as a general rule, they are not registered because they cannot register. There is an obligation, as I said, for treaties to be registered, but the burden is on the state to do that. So it's not an entirely satisfactory arrangement, but that's where we are today. So in respect of treaties entered into by international financial institutions, in the case of those entered into by specialized agencies of the UN, there is a registration of at least some of the details of the treaties that have been entered into. In relation to the agreements entered into by the non-specialized agencies, then in most cases, there is no registration. Occasionally, a borrowing country or a country providing a guarantee will itself register its treaty. So I had said that the International Law Commission, when it prepared the draft articles on the responsibility of international organizations, it had identified some key elements about international organizations, one of which is that the international organizations are established by treaty or other instrument governed by international law. And as we noted in the case of IFIs, they are all established by international treaty. So that's all I wanted to say about treaties. Now, the draft articles on the responsibility of international organizations, they also note that international organizations must have international legal personality. So what do we mean by this? Today, it's accepted that international organizations, including international financial institutions, have legal personality. This means that they have a legal existence which is independent of the parties that created them. So this implies that they may, for example, own property, enter into contracts, sue and be sued. So this is not so different from a normal corporation where the corporation has a legal identity and a legal existence and legal powers that are independent of those of the members that have created that institution. So it's the same with international institutions. So international organizations do have legal personality. Now, before the Vienna Convention, it was not entirely clear that this was the case. But there was clarity provided in 1949 by the International Court of Justice in an important advisory opinion called the reparations case. And factually, it's a very interesting case. It was a situation where very early on, the UN sought to help alleviate some of the difficulties that existed then in the Middle East and in what was then the remnants of the British mandate in Palestine. And a very senior official of the UN was dispatched to try and usefully contribute to resolving some of the very difficult problems that existed. And he, in fact, was assassinated on his trip. And the UN wanted to hold accountable the party which they alleged was responsible for this. And they wanted to do that for a number of reasons, partly because they needed to make a point that they can't have their officials be treated in so outrageous a manner as to be targets of assassination attempts. But there was also a practical reason, which is that it was necessary to provide some kind of support for this person's family, which is common today for international civil servants. If you die during the term of your contract, then there is some support that is provided by the employer. So there was an attempt there was a proposal that the UN would pursue those that it held accountable, but it wasn't clear whether the UN had this power, had the authority to do that. So it sought an advisory opinion from the International Court of Justice. And the International Court of Justice confirmed that the United Nations does have legal personality. An international organization can have legal personality. And with that is the ability to enter into contracts, enter into treaties, and to seek to have them enforced. So that really became part of customary international law. It's part of the law today. It's restated in the Vienna Convention on Treaties, but irrespective of whether a state is party to the Vienna Convention on Treaties, that provision is binding on all members. So international legal personality is very important. This implies an organization has a will of its own. In the case of most international financial institutions, this will is determined by the governance bodies carrying out their functions. So we will discuss this further later, but for now we may note that in the case of most international financial institutions. The governance bodies are the Board of Governors, the Board of Directors, and the President. So the names may vary, but essentially these are the three governance bodies. Now, the constituent agreements of IFIs usually have an express provision saying that they have legal personality and what this implies. The charters often state that the executive head of the institution, frequently called the president, is the legal representative of the organization. So looking at those three aspects of international organizations arising from the definition of the International Law Commission and its draft articles on the responsibility of international organizations. Again, the international organizations are established by treaty, which we've discussed. They must also possess and do possess international legal personality, which we've now discussed. And thirdly and finally, the International Law Commission says that international organizations may have as its members not only states, but also other entities. That's the expression, other entities. Now, with regard to membership, traditionally, only states had treaty-making capacity, and therefore the capacity to become members of a treaty-based institution. But during the course of the 20th century, underscored by cases such as the reparations case that we discussed, the ability of international organizations to enter into treaties became recognized. So today we see international organizations as members of other international organizations. So for example, the European Bank for Reconstruction and Development has, as most of its members, states, but it also has a couple of international organizations, including the European Investment Bank. So one international organization holds shares in another international organization. The same is true at the AIIB. So almost all of the members are states, but Hong Kong, which is not a state, is also a member. And we will discuss membership in a bit more detail later. But for now, we can see this as an example that bears out what the International Law Commission had to say in its draft articles on the responsibility of international organizations. That is, that international organizations may have as its members not only states, but also other entities like the international organization at the EBRD or like the sub-sovereign at the AIIB. So that's all I wanted to say in relation to the Vienna Convention on treaties, and it's all I wanted to say in relation to the draft articles on the responsibility of international organizations prepared by the International Law Commission. So let me just pause there and see whether there are any questions. And if you have any, please make a note in the chat function now. So Professor Sato, I see that you have made a comment in the chat. This is for the benefit of everyone. And you have a number of issues that are covered there. One of them I noticed you talk about Myanmar. Mm-hmm. So that's quite interesting because the case of Myanmar raises an issue about how international financial institutions recognize, quote unquote, the states, not only those in which they invest, but also those which are members and are only contributing capital, but not expecting financial support. So this is a difficult issue, and it's a difficult issue for a number of reasons. One is that international financial institutions, as a matter of public international law, do not extend recognition to states. That's solely the preserve of states themselves. So even the United Nations doesn't do that. So if you ask the question of is a particular place, is it recognized as a state or not, the answer always has to be, well, you have to ask other states. And usually other states all agree, but sometimes they don't. And there's no shortcut to this. So you can't say, well, are they a member of the UN? For example, Switzerland was not a member of the United Nations until the 1980s. But no one doubted that Switzerland is a state, and was a state, and remains a state. So that can be quite difficult. So in the case of states that are, or places that are recognized as states by some countries, but not by others, the answer has to be, well, this place is recognized by some states and not by others. It's not really for an international organization to extend recognition. However, practical issues arise, such as knowing whose credentials to accept in instances where there may be competing governments. And some organizations have policies that deal with this, and some don't, but ultimately it's a matter for their respective boards of governors to determine. So in the case of Myanmar, you have this coup now. So the question, I think, that international organizations that have Myanmar as a member would be asking themselves is, who is in control of the country? Is there control? Is there a de facto government, even if it is not a government that has come into being in accordance with the normal.
That means it depends on the IFIs. For instance, ADB and AIB might have a different status for this recognition fee. So one can also recognize the new military regime, or the other one is not, and so it's a bit awkward, and it's a cooperative loan systems. It's very difficult to make some.
Yes, and another set of difficulties arises where a state that hosts an international organization, or maybe that will host a meeting of that international organization, such as its annual meeting, may not recognize a particular government of a country, or may not as having the lawful control of that government, or it may not recognize a state at all. And yet that state or the government of that state might be doing normal business with the international organization on the territory of the complaining state. And then the question becomes, well, does the host state have an obligation to, for example, provide visas and traveling facilities to a person from a state that is not recognized by the host state, but which is recognized, quote unquote, by the international organization? So that's an issue you see popping up from time to time. And it does happen at the UN quite a bit. So the United States may not be very happy with some of the people who are coming to meetings of the UN. And there is a tenet in international law that says that accommodating the presence of someone to attend a meeting of an international organization does not imply recognition for domestic purposes on the part of the accommodating state. But it does raise a number of quite difficult practical issues.
But practically maybe because this IFIs is a part of the UN system. So I think UN system is a hierarchy probably is United Nations itself, New York headquarters or General Assembly of this could be a kind of a authoritative sort of guidance or some sort of practice.
Yes, I think that's right. I think that the General Assembly of the United Nations can be rightly viewed as being the most internationally inclusive or the most internationally representative body that we have. And given that they have the one state, one vote rule at the General Assembly, I think that if one wants to know how does the international community recognize or deal with particular states, then looking at the practice of the General Assembly can be very instructive. And I would expect that at international financial institutions that are UN specialized agency, then there's a lot of deference that would be given to the UN. But I would also expect that international financial institutions which are not specialized agencies of the UN would also look to the practice of the General Assembly as well, not because it's binding on them, but because it will inform their own thinking. And then you also mentioned Taiwan. So Taiwan is an interesting example. In the case of the AIIB, we have, and we'll discuss this a bit later, we have a provision that makes membership available potentially to all members of the IBRD or the ADB. So in some organizations, eligibility is expressed in terms of countries applying. So then you have the difficult issue of having to decide whether the applicant is a country or not. So no such problem exists at the AIIB. One simply looks at whether the applicant is a member of the IBRD or the ADB. And Hong Kong, for example, is a member of the ADB, which is why I was eligible to apply at the EBRD. Taiwan is also a member of the ADB and therefore would be eligible to be considered for membership at the AIIB. But of course, there are a lot of political considerations affecting the various countries that would play out there. But the question of whether or not it is a country does not need to be addressed at the AIIB. Okay, so let me proceed. I wanted to talk now about an important aspect of international organizations generally, and one which is especially important in the case of international financial institutions. And that aspect is the privileges and immunities of international organizations. So international organizations are endowed by their members with special status and exemptions, privileges and immunities under the respective laws of those countries. These include immunities of their archives and assets from any kind of judicial process. They also extend to the communications of international organizations and generally exempt them from all domestic tax obligations. These privileges and immunities are common to all international organizations. Also common is jurisdictional immunity, about which I will say more now. The charters of most international financial institutions limit the ability of the institution to be brought before local courts, or for the officers of the institution to be subjected to local legal processes. Now, the terms of this immunity vary from one institution to the next. The IBRD and the AIIB probably enjoy the most extensive protections. That is, they may not be brought before a court of a member unless, in effect, those institutions have expressly agreed. However, note that even the IBRD's and AIIB's jurisdictional immunities do not hold where the court is of a country that is not a member of the institution. For example, Japan, in the case of the AIIB. So if a court in Japan were to have jurisdiction over a matter involving the AIIB would not be able to avoid engagement with the Japanese court by relying on jurisdictional immunity, because jurisdictional immunity exists by virtue of the charter of the AIIB, and Japan is not a party to the charter. It's possible that there is a domestic Japanese law that would provide some additional jurisdictional immunities, even where Japan is not a member of an international organization. And there is a very difficult argument that customary international law would also provide some jurisdictional immunity for international organizations in relation to actions brought against them in the courts of states that are not members of those organizations. But I think it's a very difficult argument. So this is a practical issue because it's not always possible to organize one's affairs in such a way as to avoid the jurisdictions of courts of countries which are not members of the organization. So looking, for example, from my experience at the EBRD or the AIIB, often a very efficient way of reaching the private sector is by investing in funds. Funds traditionally are incorporated in places where there are high degrees of tax efficiencies in terms of attracting investors. But equally, those places are very often not members of the international organization. So a good example is the Cayman Islands. So many funds are established in the Cayman Islands. If you want to attract investors, the laws of the Cayman Islands are very well known to those investors. The courts have a very predictable fashion of applying those laws. The tax regime operates in such a manner that there is no double taxing of profits and various other activities. So funds are established by others in the Cayman Islands, the EBRD or the AIIB or the IFC, which I'm not sure if Cayman Islands is a member of the IFC, but let me take the AIIB or the EBRD, where the Cayman Islands is not a member. In those instances, if there is a falling out of the shareholders of the fund, or the members of the fund, or the shareholders of the company established in the Cayman Islands, and if the AIIB or the EBRD are drawn into that dispute, often because they happen to have deep pockets and parties like to sue them in those instances, then they cannot rely on jurisdictional immunity to avoid the court determining the case. So at the other extreme are those institutions whose charter does not provide for jurisdictional immunity at all. However, even in those cases, a domestic law may exempt the organization in certain circumstances. So in the United States, which hosts quite a number of international organizations, particularly international financial institutions in Washington, sometimes there is a domestic law that can provide some benefit to the international organizations. Note too that where jurisdictional immunity does exist, it can be waived by the organization. And in some instances, the charters of the organizations provide for an express duty to waive the immunity. This exists, for example, in relation to the functional immunity of international civil servants. So they cannot be pursued in the domestic courts, but in instances where a miscarriage of justice would otherwise occur, if a waiver can be facilitated without damage being done to the institution, then the president of the institution is obliged to provide a waiver of that jurisdictional immunity. So a waiver is possible, and a waiver is sometimes mandatory. So there was a lot of excitement last year in international organization circles, and particularly in the circles of international financial institutions, about a decision of the United States Supreme Court regarding whether the IFC had jurisdictional immunity on the territory of the United States. So as you know, the IFC is headquartered in the United States. It has its principal office in Washington. It also has a resident board of directors, so important decisions are also made in Washington. And this case was the so-called JAMS case. And it's important to remember that the IFC charter itself does not provide any jurisdictional immunity. And the IFC doesn't have a special agreement with the United States as the country hosting its headquarters. So let me just spend a couple of moments explaining what that case was about. And I think it's a good one to think about jurisdictional immunity. So in the IFC and JAMS case, the IFC had financed a project in India. And it was an infrastructure project. And the parties were in agreement that the IFC should provide funding to support the development of this project. And some third parties that were affected by this project, that claimed to be affected in an adverse way, they sought recourse not from the Indian government or from the project parties, but from the IFC. So their argument that they wanted to pursue was that the IFC financed this particular project. They either shouldn't have financed it, or they should have financed it if the design was done differently in a manner that wouldn't cause them harm. So they sought to sue the IFC. And the IFC said that, no, you can't do that because we're an international financial institution and we have always had jurisdictional immunity on the territory of the US. And their main argument was that there is a domestic law that comes to their aid. So in the case of the IBRD or the AIIB, there is absolute jurisdictional immunity that is set out in the charters of those organizations. But the IFC has no such provision in their charter providing for jurisdictional immunity at all. In some instances, international organizations also have a bilateral agreement with the host country. So at EBRD, there is a headquarters agreement. At the AIB, there's a headquarters agreement. And so those often provide for jurisdictional immunity over and above what is provided for in the charter of the organization. But the IFC didn't have that either. So the only thing the IFC had was the benefit of a domestic law, and it is that domestic law that they pleaded. And the domestic law dates to just after the end of the Second World War. And it was at a time when, as you know, because of Bretton Woods, there were going to be international organizations established in Washington. And that law basically provided that international financial institutions that were recognized, as it were, by the United States and which were headquartered in the US were to enjoy the same jurisdictional immunity as states. Now, immediately after the Second World War, states enjoyed absolute jurisdictional immunity. So any activity of a state was beyond review in the domestic courts of any country. That was the nature of international law and practice at the time. But over the years, that changed so that the commercial activities of states could be examined by domestic courts. So the question then became for the IFC whether that law ought to be interpreted in the way that was intended in the 1940s, or whether it should be interpreted in a manner consistent with the limited jurisdictional immunity that states enjoy today. And the IFC had argued that the correct moment in time is the 1940s, because the international organizations, the way in which they work and so forth has not changed. And at the time, they had absolute jurisdictional immunity and nothing has changed. And that argument was upheld by the Court of First Instance, and it was also upheld on appeal. But the IFC lost at the Supreme Court, and they lost resoundingly, almost unanimously. And the Supreme Court said that no, the jurisdictional immunity of international organizations on the territory of the US is the same as that of states under the law. So the IFC now did not have any jurisdictional immunity by virtue of that statute. However, the Supreme Court observed that the mere fact that the IFC doesn't have jurisdictional immunity by virtue of the domestic law is not necessarily fatal to its case. For instance, it said, the Supreme Court said, it was open to the members of the IFC to provide it with jurisdictional immunity. it was open to the United States to provide jurisdictional immunity under a bilateral arrangement. So it's very difficult, of course, to amend an international treaty of that complexity with so many members. And there's also a tradition of the United States not entering into bilateral agreements with international organizations. But so that was not very helpful. But the Supreme Court also observed that the mere fact that there is no jurisdictional immunity by virtue of this special law does not mean that the courts necessarily have jurisdiction. So in the ordinary course, if you want to pursue a case in the US, you have to demonstrate that your transaction or your claim or your complaint or your damage has some connection with the US. And the US Supreme Court observed that the mere fact that decisions had been made in the United States would not be enough to draw the case before the courts of the US. I believe that the loan was also denominated in dollars, but it seems that merely using the currency of the United States also is not sufficient. But they said, this is not for us to determine. We send this back to the lower court to decide whether the normal rules on jurisdiction have been met. And I'm not sure where that process now stands, but I believe that it will be quite difficult for the plaintiffs in that case to make out that they have jurisdictional immunity. So if they want to sue, they would probably have to sue the IFC in India, or they could sue other parties. So that's where we are with the JAMS case. And I spent a little bit of time on it because it's quite an important case for understanding jurisdictional immunity. It was also very topical, so you can read quite a lot about that. So that's a question really for you. And let me pause here just to ask you the question, something for you to think about. You can drop me a line on the chat function if you like, or maybe we'll even discuss this at the next seminar or a subsequent seminar. But a question for you is, why should international financial institutions enjoy jurisdictional immunity? And what about other immunities, such as tax immunities? So they don't have to pay tax, and their staff, international civil servants, as a rule, do not have to pay tax on their compensation. So is that appropriate? What's your view? So just let me pause for a couple of minutes, encourage you to reflect on jurisdictional immunity. Is it a good thing? Is it an antiquated notion? Should international financial institutions, maybe they should just be like normal companies? They get sued, they just have to defend themselves wherever they are or wherever they're sued. Or is there a case for treating them in a special way? So while you're reflecting on that, let me try and address two of the questions that have been raised under the chat function. So I can't read the Japanese script, so I can't see who this is from. But there's a question about the role of the private sector. There's an acknowledgement that, of course, the private sector's role is critical in development. However, the questioner asks, I would like to know more about the specific standards that international organizations use to decide which private sectors or what kinds of situations that they suppose are appropriate to provide financial assistance. So it's a good question. There are some constraints that are set out in the charters of the institutions that determine what kind of private sector activities might be off limits in broad terms, and there are many policies. So one thing that is common to a number of the institutions, including the EBRD and the AIIB, is that there is a provision that requires that sound banking principles, that's the term that's used, sound banking principles be applied in respect of the operations of the institutions. So this means that if you make a loan, you should expect it to be repaid. If you make an equity investment, you should expect to get some return that's appropriate to the risk that you're taking. So that will exclude some activity in the private sector, because if it doesn't meet sound banking principles, then as a rule, it cannot be financed. Another consideration, also reflected in the charters, is that there is a provision that is designed to not have the organizations displace funding that is coming from commercial banks. So if there's a perfectly financeable project somewhere that is attracting lots of interest from commercial banks and other commercial financiers, then the international organization has to ask itself a question of whether investing in their project would bring anything to the project that the commercial banks cannot bring. And if the answer is that the international organizations are not additional in any meaningful way, then they ought not to finance the project. So there is this other constraint on private sector activities that operates there as well. And these are provisions that exist in the charters of the institutions, many of the institutions. There are also strategies and policies that direct the kind of investment in the private sector. Some are in the nature of identifying areas that ought not to be financed, and others are in the nature of identifying priority areas for finance. So in the latter category, there are a number of prohibited areas. So no international financial institution wants to be associated with financing certain activities, such as those which are viewed as being socially undesirable. And in an abstract level, it's easy to list them, but when you come to apply them in practice, it's a little bit harder. So an example is gambling. So if you want to develop a big casino, the international financial institutions will be unlikely to finance them. But financing hotels, particularly for tourism, that's very common for many of the international financial institutions that invest in the private sector. But if you have a very large hotel that has a couple of slot machines, can you finance the hotel? Probably under these policies, provided that it's really an incremental and very modest part of the activity that is being financed. Another example would be financing hard liquor. So the international financial institutions, they don't want to be associated with financing vodka production in Russia. But it seems that financing wine production is okay, or beer production is probably okay. So again, easy to develop an abstract list of things that you don't want to be associated with, but quite hard in practice sometimes to decide. So these are area, or another one would be tobacco production. So no international financial institution is going to finance a tobacco project. And then you have many strategies and policies of the organizations that channel the focus of the organization's energy into financing certain kinds of private sector activity, which are viewed as being most likely to achieve the mandate. And so at AIB, you can see all the strategies on the AIB website, and they're accessible also via the link, one of the links on the role of law at the AIB, the document that was distributed to you. And there you can see that the bank has strategies in relation to investing in transport, or in energy, or in sustainable cities, or in digital infrastructure. And these all involve value judgments, and some organizations are, maybe value is not the right word, but these all involve judgments about what is most appropriate. And some organizations focus more on some activities than on others. So that's the answer that I will give to that question. And the other question that's been raised in the chat box is that, and she's reflecting on why it is that international organizations sometimes become members in other international organizations. So in the case of the EBRD, there are 2 European Union institutions that are members of the EBRD, and between them they hold 10% of the capital of the organization. And the way the governance arrangements work out at the EBRD, this enables both institutions to have a director representing their interests at the board. And the mandate of the EBRD is very closely aligned with the foreign policy objectives of the EU, not just the foreign policy objectives, but the policy objectives generally. So I think that the 2 EU institutions are there so they can help influence the strategies and policies of the institution, because they know that the institution's activities are going to bear on their own objectives in furthering the European project. And it's, I think, having those institutions that can actually be quite attractive to the host institution as well. So if you're the EBRD, it's great to have 2 institutions which together hold 10% of the shares and which have very strong financial credibility, because that helps in ensuring that capital contributions will be made on time. If there is to be a call on the capital, then you can be confident that it will be honored, and all this is relevant for the setting of credit ratings. So I think it can be also very attractive for the institution as well. So that's all I wanted to say about jurisdictional immunity, and I hope that what I said just now was responsive to the questions that I raised. Now, another aspect of the status and privileges and immunities of international financial institutions is something called preferred creditor status. So another benefit that IFIs enjoy in certain circumstances is preferential treatment in respect of the finance that they have extended. So this arrangement, which is designed to recognize that IFI lending is often the last resort available to members facing financial difficulty, is supported by a combination of rules and practices. First, quite commonly, the charters of international financial institutions will provide that the members may not impose any restrictions on the conversion of currencies or the transfer out of the members' territories of hard currency. This is especially relevant in private sector operations. Therefore, moratoria on hard currency payments ought to exempt those payments being made to international financial institutions. Now, where a member is unable to honor its repayment obligations to other states, or to state agencies such as export credit agencies or their surrogate commercial banks, then the established practice is that any rescheduling of debts which occurs at the so-called Paris Club shall exclude IFIs. So that's quite a lot to take in. So maybe I can go back over that and explain it a bit more fully. So international financial institutions often say themselves, and others say about them, that they have preferred creditor status. And when this is spoken about loosely or in general terms, it means that they have a better treatment than other creditors in the event of certain difficulties befalling the state that has borrowed funds from the IFI or the state that is hosting a project on the territory of an IFI. So there's two situations in which the preferred creditor status can arise. So let me deal with the second one first, because I think it's easier to understand and the legal basis for it is clear. Under the charters of the international financial institutions, the members all say that they will not impose currency restrictions. So if the AIIB or the IFC or the EBRD make a loan to a company that is established in a country that is having a lot of financial difficulties, then in the event that the government of that country decides to impose certain kinds of restrictions, then the international financial institutions will be exempted. The typical action that is taken by a country that is facing a shortage of hard currency is to limit access to it. So it may say that all obligations the government may say that hard currency will not be available to support loan agreements entered into by entities of that country with lenders from third-party countries for the next 6 months or 12 months. Or it might say that any dividends that are to be paid shall not be paid in hard currency during the period of that moratorium. And in those instances, the IFI will not have to be concerned. When I was at EBRD in 1998, I think, there was a difficult financial situation faced by Russia, and it imposed a moratoria on all hard currency payments, and it issued a decree prohibiting any Russian entity from honoring an obligation to pay hard currency to an international lender. But there was a specific exemption provided for the EBRD and for the IFC. So that's how that works in practice. And it's underpinned by the direct legal relationship, the direct express legal relationship between the country and the IFI. So there is something in the charter. There will also be some bilateral arrangements with the country that reinforce this. Now, one very common way in which international financial institutions investing in the private sector will support projects in very difficult countries, particularly countries where the political risk is very high, is that they will share this aspect of their preferred creditor status with qualifying international commercial banks. And they do this through a mechanism known as the AB loan. So the AB loan is a mechanism that was developed by the IFC, and then subsequently by other international organizations that finance the private sector. So if we are dealing with Myanmar now, if you're a commercial bank, you would probably be reluctant right now to invest in Myanmar. But if you are an international financial institution, the whole purpose of the institution is that you continue supporting countries even when they are in difficulty. So leaving aside questions about who is in control of the country, if an IFI were now to invest in a private sector project in Myanmar, then there may be difficulty in mobilizing sufficient lending to support the project, because the IFI will very rarely finance all of the financial needs of the project. Probably it's going to finance maybe about a third of it at most. So it needs to mobilize this other support. So there can be maybe there'll be some parallel loans from some Myanmar banks, probably not much, and they probably can't lend for long terms, and they may not be able to lend in hard currency, but they may have maybe some local currency costs to the project. So there may be some financing from that source. You may have a foreign sponsor for this project, and they can put in a certain amount of equity, maybe make a subordinated loan, and then you'll have the international organization. But a normal commercial bank won't want to finance a project in a country that is viewed as being politically unstable, with a certain amount of uncertainty over the medium term. But they may be interested in financing a project if the political risk can be alleviated. And one way in which that can be done is by the international organization providing an AB loan. So if the project needs $100 million, then the international financial institution could provide, say, 60 million of that, and then 40 million of it would be funded by the commercial bank. So the lender of record is the international financial institution only. If there is a problem with having access to hard currency funds, then the lender of record, the AIIB or the EBRD or the IFC, will have the benefit of its preferred creditor status, so it will be able to access the hard currency payments needed for the obligations under the loan agreement to be honored. Of course, there's no protection against commercial risk, so political risk can be mitigated in this way. So that's one aspect of preferred creditor status, which really plays out in relation to private sector investments. The other aspect of preferred creditor status plays out in relation to the sovereign investments, those loans that are made by international organizations to its members, or loans made usually to sub-sovereigns or to non-sovereign entities, but with a guarantee from the state. So if an international organization is financing the development of the railway, then the railway lines and the tunnels and the infrastructure may be owned by a legal entity that's owned and controlled by the state, or it may be a department, governmental agency. But there could be a loan directly to the state, which it then uses for this particular railway purpose, or there could be, if the railway company or railway body has legal status, there could be a loan to that railway borrower, with a guarantee from the state. So either way, there is a state obligation, either a sovereign loan or there's a sovereign guarantee. And often these are, in general terms, just referred to as sovereign loans or sovereign obligations. Now, when there are these sovereign obligations, sometimes it happens that the member runs into difficulty and is not able to honor all of its international obligations to all of the official lenders. So the official lenders will be other states and also those claiming under them. A very common player are the export credit agencies. So what happens is if a country is unable to honor its obligations to official creditors, then there can be a meeting of the official creditors, and this meeting is referred to as a Paris Club meeting, because traditionally they would take place in Paris and they were chaired by a senior official from the Treasury Department of the government. But they could, of course, take place anywhere. And they probably will take place by Zoom these days, I don't know. So at that meeting, the principal creditors would negotiate an arrangement whereby they will provide some relief to the country experiencing difficulty. This relief could take the form of rescheduling some of the obligations or providing a payment holiday, or it could even involve forgiving some of the obligations. But the most common form it would take is rescheduling of the obligations. Hence the expression Paris Club reschedulings. So in those instances, around the table, there is usually no one from the international financial institutions. So the international financial institutions will be exempt from Paris Club meetings, and they will not be expected to enter into negotiations to reschedule their debt. And the reason for that is because they have preferred creditor status. And this aspect of preferred creditor status is not regulated in the Charter. It is a practice. There is a recognition in the international community, particularly among the community of international lenders, that the international financial institutions, which are owned and controlled in the main by those lenders, that the international organizations are lenders of last resort. So there's no point in rescheduling the debts of the international financial institutions, because if you treat them the same as every other creditor, then you really undermine their ability to deliver support to the countries in need when those countries most need it. So in the case of the Russian Federation in the late 90s that I mentioned before, when I was talking about the moratoria, that arises in respect of the private sector dimension of preferred creditor status. But of course, the country could well have experienced difficulties in meeting its obligations to the international official lending community as well. But irrespective of whether there was a rescheduling of official debt, the EBRD and the IFC, the IBRD, all the international organizations, they continue immediately afterwards to provide support to that country. Whereas commercial banks, once they're bitten, they're not going to run in the next day and provide fresh funding. But for the international organizations, they do that. That's what they do. They support the countries that are in most need at the time when they're in most need. and they need to be protected and supported to enable them to do that. So that is why they are excluded. So there is no law that requires that, but that is the practice. Now, there are some difficulties in terms of implementation and some discussion about which international organizations are qualifying to be excluded from this kind of rescheduling. But broadly, that's how that works. So that is preferred credit status. So a question for you to think about is, well, what do you think of this preferred creditor status? Do you think it's fair? Is it appropriate that the international organizations should have this preferential treatment in these circumstances? Or should the situation be different? So you are all students, but put yourself in a situation, think of 10 or 20, let's say in 10 years' time, you might be in a position of influence because you have to decide whether some international organizations are going to be included or excluded from Paris Club reschedulings, or you have an opportunity to codify the rules around the workings of the Paris Club and its reschedulings. If you make the rules or you were advising, you have some influence, what would your view be? What would your advice be? So that's something to think about. So that's where I will stop for today. Thank you very much for your attention. Do send some comments to chat. I hope we've managed to answer most of the issues